Hello everyone, myself Monica D, pursuing 4th year BBA LLB and Bishop Cotton's Women's Christian Law College, Bangalore. Today I am here to talk about vicarious liability. So what do you mean by vicarious liability? So vicarious liability refers to a situation where someone is held responsible for the action or omission of another person. There exists a relationship between two persons called the master-servant relationship. Vicarious liability is one of the most important topics of law of torts. In a workplace context, an employer can be liable for the act or omission of its employees, provided it can be shown that they took place in the course of their employment. This means the holding the master responsible for the action of servant should be in course of employment. We need to remember that tort law has evolved from various judgments given by the courts. The reason why master is held liable for the servant's wrongful act is that in various cases it was found that the servant did not have enough resources to compensate the plaintiff. The very purpose of awarding the damages is to restoration to the position before the wrongful act was done. The main essential of vicarious liability are there should be a master-servant relationship among the person. Second one, the wrong act should be done. Third one, the wrongful act should be done in the course of employment. So, to determine the master-servant relationship, there exist two tests. First one, hire and fire test. In this test, the one person should have the power to hire and fire the other person. The person who has the power to hire and fire, that person is called as a master, and to whom he fires, that person is known as a servant. Direction and control test. In this test, the person who has the power to direct or control the other person can be known as master in that case. So wrongful acts in the course of employment are of two types. Wrongfully act should be authorized by the master. Authorized act were done in wrongful manner. For example, A is oldest and the most loyal servant of B, working since 1999. One day C came to B office and abused him. B in frustration told that I wish I can kill him. A was there, he heard the statement and to please his master he killed C. In this case, B is not held liable for wrongful act which was done by his servant because here the knowledge of this act was not there to the master's side. So illustration 2. Z during lunch hours went back home to have lunch at home. He saw his wife talking to a handsome neighbor and out of anger brought his axe out and killed them both. Later pleaded he was in the course of employment. Hence, this will not stand as a course of employment as the master did not hire him for such purpose and the act was out of course of employment. Therefore, actions which are not directly or indirectly authorized by the master would be considered under the course of employment. If a servant acts in defiance of the express prohibition of certain action by the master, then the master cannot be held liable. A simple warning by the master to the servant or general guidance cannot be construed as being expressed prohibition. The master should have gone out of ordinary way to prohibit the servant from doing that wrongful act. Vicarious liability of the state. The government of India may sue or be sued by the name of Union of India, and the government of the state may sue or be sued by the name of the state and may subject to any provision which may be made by an act of parliament or of the legislature of such state enacted by virtue of powers conferred by the constitution. Sue or be sued in relation to their respective affairs in the like cases as the demonstration of India and the correspondent Indian states might have sued or been sued if the constitution had not been enacted. One important thing, husband-wife relationship is not like master and servant relationship. Thank you.